a little higher than $635.7 million paid in 2010 to service the domestic debt. It was therefore timely and necessary for the government of the Gambia, through the leadership of the President, to set up a commission of inquiry into tax evasion and other corrupt practices to gauge how this decline in revenue collection is caused by tax evasion and other corrupt practices. Under the head of corrupt practices, which runs throughout the report, the Commission was able to gauge the level of malpractices by members of the public and GRA officials. To ensure the proper performance of the systems in place for revenue collection, the Income and Sales Tax Act of 2004 was enacted and revised and amended, and it was enacted to revise and consolidate all the laws relating to income and sales tax and all matters connected therewith. The provisions of this act are referred to throughout this report. Hearing and evidence. The hearing of the Commission of Inquiry commenced on the 5th of December 2011 and concluded on the 28th of March 2011. Between this period, over 300 witnesses appeared and reappeared before this commission on matters related to income, sales, PAYE, capital gains taxes, and issuance of dot checks. Some appeared with evidence of payments of their taxes. Most of the hearings of the Commission of Inquiry were held in open court, covered by all the major print media in the Gambia. At the conclusion of the hearing, the Commission evaluated all the evidence before it and noted that the methodology adopted by the GRA in assessing taxes or accepting taxes paid after self-assessment was flawed. In order to highlight this, the Commission then conducted a random reassessment of witnesses already called in before this Commission. For the purpose of this reassessment of income, sales, and PAYE taxes, the Commission categorized the taxpayers under the following heads: legal practitioners, medical practitioners, hotels, insurance companies, engineers and consultants, and other companies. For legal practitioners, the Commission reassessed 10 practitioners on the roll who appeared before the Commission. Incidentally, most of these were lawyers with the most experience of service at the bar. The rest was a random selection based on size and the evidence the Commission heard. The Commission also conducted a random reassessment of all transactions considered by this Commission on the assessment of capital gains tax. Findings. The outcome of said reassessment exposed a serious flaw in the assessment process and procedures adopted by GRA, which is depriving government of large amount of much needed revenue. In all, the Commission conducted a reassessment of only 50 income, sales, and PAYE taxpayers and 14 capital gains taxpayers. These reassessments exposed a great anomaly in the taxation methodology and negligence by GRA in tax administration. Specific findings. First is on the declaration. During this process of reassessment, the Commission found that there were some outstanding payments due on taxes to be paid. The Commission found that selected taxpayers were wrongly assessed and therefore said taxpayers paid less tax than required. During this reassessment exercise, the Commission suspected that most of the income claimed to have been earned in any given year was greatly underdeclared. This the Commission found more prevalent with lawyers. Our methodology for reaching this conclusion is based on their seniority at the bar and the fair market value as defined in Section 4 of the Income and Sales Tax Act of the services provided in this field. We therefore randomly reviewed the income declared of a lawyer of 16 years legal standing and compared the income declared and tax paid in any given year and found that it was more than the income declared and tax paid for a lawyer of 32 years standing at the bar on similar services. There is, however, no conclusive proof to support this other than the fair market value rule under the Income and Sales Tax Act. The Commission, however, strongly believes and firmly concludes that there is a case of serious underdeclaration of income earned with a view to evade the payment of taxes. The Commission therefore recommends a thorough and detailed inquiry and investigation to be conducted on this issue in order to ascertain the magnitude of underdeclaration of income by taxpayers. 2. Wrong or non-assessment. On the issue of reassessment of these selected taxpayers, the Commission found that selected taxpayers were improperly assessed. Some were not even assessed. We also found that there was limited or no information on assessment of some taxpayers, particularly large taxpayers. We found that the methodology adopted by GRA to assess taxpayers is by assessing them based on assessable income, that is, after an allowable deduction. It is worth stating that Section 34(1) of the Income and Sales Tax Act provides for allowable deduction on any expenditure incurred in deriving gross income. Therefore, what the Commission found was a taxpayer would declare an income and then assess himself on an assessable income after deducting an alleged expenditure. The problem arose where no proof of expenditure is attached to support the figure reached in calculating the assessable income. It is straight law that anything alleged must be proved. Therefore, we consider that the burden rests on the taxpayer to prove any expenditure incurred to warrant an allowable deduction, and such proof must be in the form of receipts or any other form of documentation. Without that, the Commission considers that the assessable income claimed must be disregarded. It is based on this consideration, and in the absence of any proof of expenditure to warrant an allowable deduction, that the Commission proceeded to reassess the selected taxpayers on declared income. The outcome of this reassessment has shown a great loss of necessary revenue for government. The total outstanding amount of tax debt of selected taxpayer reassessed are as follows. Out of 10 legal practitioners reassessed, they are found to be owing $20,711,239.07. Out of 7 medical practitioners reassessed, they were found to be owing $5,337,707.13. Out of 6 insurance companies reassessed, they were found to be owing $98,537,355.76. Out of 12 hotels reassessed, they were found to be owing $439,503,816.98. Out of 7 consultants and engineers reassessed, they were found to be owing $15,500,000